NACDL is the association of the nation's criminal defense bar.
So this first slide is just to kind of let you know where we are headed. Dr. Matthews is going to start by giving a brief, probably too brief, overview of probabilistic genotyping software, the basics and kind of the concerns, like I said, particularly from a computer science angle about this type of software. Then we're going to talk about litigating access to source code, which some of the issues of which one of my colleagues, Rebecca Wexler, is going to talk about right after us. But we're going to talk more broadly about litigating access to source code in addition to the trade secrets discussion that Rebecca is going to have in a few minutes, or in an hour. Then we're going to talk about protective and disclosure orders when you are talking about source code in general. And this is, again, based on our experience in Kasha's case. And then we're going to just do some reflection and talk about takeaways, things that are worth you knowing as you tackle this in your clients' cases. And then if we are lucky, we'll have a very short Q&A if we can get through all the material in time. So Dr. Matthews, why don't you take it away?
Thank you so much. So the first thing to say about probabilistic genotyping software from my perspective as a computer scientist is that it is complex software. And as citizens of the modern world, we all know that complex software has bugs, right? We've all had our cell phones crash, the PowerPoint crash, Word crash, and we have this belief that even if we don't report the error, that eventually market forces will make that software better. Someone will report it, they will care, it will get better. The thing about forensic software is it is deployed in an environment that does not incentivize iterative improvement. The only market forces at play are basically admissibility. And that is a big problem because complex software has bugs. And there is a huge, unquestionable consensus among the software engineering community about what it takes to make reliable software. The process of documenting the requirements, the specifications, the design, the implementation, the testing, the maintenance, things like recording the changes to software over time in a database that says, this is the change that was put in, why it was put in, a database of bug reports, and what happened with those reports over time. Any software engineer, even software engineering students, understand this process is necessary. And the general public, I think, might not necessarily. I see an over-reliance on software, like similar to over-reliance on statistics or science sometimes. Sometimes you get oh, the software said so, it must be right. And anyone who builds software knows that it is just not like that. Even, like I said, introductory software engineering students know, okay, I tested this thing completely on all the test cases I could think of, and I turned in my homework, and the TA or the professor had a bunch of tests, and I failed them all. I didn't think of that. Or anyone who's ever deployed software in the real world is like, our team worked really, really hard to get this initial release, and we tested as much as we could in all these platforms, and then we released it, and we started to get all these bug reports from the field. I don't expect perfection out of any software because I understand the process. I do expect for it to be deployed in a socio-technical context that incentivizes iterative improvement and that actually responds to bug reports in the field, that doesn't say things like, oh, we tested it 10 years ago, that's enough, right? Or, what, you think this is a bug? You're just complaining because you're guilty. None of that is okay because software really has bugs that developers constantly say there's no way that can be broken. Okay, all right, wait a minute, yeah, all right, I see how that's broken. Oh my gosh, how did that ever work? That happens all the time. And to establish a process by which that gets short-circuited, because people don't want it looked at carefully, or where they say, oh, you're just constantly asking for more stuff, you just want more and more and more. That's not true. There is a clearly defined standards, best practices, the Software Engineering Book of Knowledge, the IEEE 1012 Standard for System Software and Hardware Verification and Validation, that says what the software engineering community knows after decades of building software about how to do it well. And another really important thing to understand about probabilistic genotyping software in particular is that while DNA analysis on a good quality sample with one contributor or maybe a known contributor and an unknown contributor, that's hard science. You can do it manually looking at the electropherograms. The whole purpose of this software, however, is to extend it into regions that could not be done manually. In other words, to extend it into much riskier territory without really a solid acknowledgement of that risk, or of saying, okay, how small or large is this sample? How many contributors? How many known contributors? We even know how many contributors. You can't pull touch DNA from a gun and say you know how many contributors there were, or whether there was a major contributor and a bunch of minor contributors. You have no idea. And if there's many common sense analogies. You can take one, for example, of if you wanted to name a song that, and that song was playing at reasonable volume by itself. That's one thing, identifying the song. A whole other thing is if you have 5 songs playing, one low, one loud, and maybe songs that sampled some other songs, so like the relatedness question. There's so many things that can make this go wrong. And it's embedded in a socio-technical system that wants to say, oh, it's admissible, so it's just fine, no matter what. That doesn't really want to own up to, one, the complexities of the actual unknowns in the situation and the real complexities of building software in a reliable process. So if you can't, and the types of data that the system outputs, these likelihood ratios, there is no definition of what is correct. They allow themselves this huge range of what could be reasonable, even for samples they know. You could take a sample of blood from the 3 of us and mix it at known quantities, and you still couldn't say exactly what the LR should be. There's no falsifiability. You can't prove it's wrong, even for known samples, let alone for a case in which there could be degradation and unknown contributors and so many questions. So that's what I would like to say to start us off, if that's okay. So many more things to say. That's the first things I'll say.
Thank you for that. So, for those of you, actually, I would love to know who has litigated DNA, just general DNA in their cases before. Has anybody in the room? Okay, so a bunch of you. Have people been seeing probabilistic genotyping software in their cases and litigating that? A lot fewer of you. So I guess there are a couple of other basics I just want to put out there so we all have common terms. As Dr. Matthews was talking about the problems with the software behind probabilistic genotyping software, I think it's important to highlight one of the points she just made, which is that this is software that purports to be able to analyze DNA samples that are too complex for a human to do on their own, right? So say low quality DNA, too little DNA, more than 2 contributors, right? 3, 4, 5 people in one DNA sample that the lab is trying to figure out, whose DNA is here. The software steps in and purports to fill this gap, but there are lots of problems with it. The other thing I just want to put out there, I guess, are the 2 largest companies or the 2 pieces of software that you will most frequently see, just so you're on the lookout, because everything we're about to talk about is related to one of them. A lot of what we're about to talk about applies to both. So one is called StarMix, STRMIX. It's developed by a company called ESR, which is based out of Australia and New Zealand. This is the largest, I believe, I'm looking over at my DNA friends in the corner. This is the largest market shareholder is StarMix. It's used prevalently in California, among other states. The feds also use it when the FBI is doing the analysis. The other company, which is the one we're going to talk about because it's what came up in Kash's case, the program is called True Allele, and it's developed by a company called Cybergenetics, which happens to also be in Pittsburgh, where Kacha's case was. So if you see these are the software programs that we're going to be talking about generally. So I want to move us to the question of litigating access to source code, because that's really where this story kind of started, where the three of us got together to work on this issue. So Kacha, why don't you tell us a little bit about the case that we actually worked on, or have been working on?
Sure, thank you. So the only reason I'm really sitting here is because I had this case, and it came up, and I was able to assemble a really good team that helped me do this. And so hearing some very high-level talk from Dr. Matthews, and if you've never heard of this stuff before, looking at my case will kind of give you an idea of what it will look like in your cases in the future, or if you currently have a case. So the basic facts of my case are that Mr. Ellis is charged in federal court with felon in possession of a firearm. And he's driving a car, allegedly. There's shoddy ID. So the car he's driving is not registered to him. The car is fully tinted. It's really dark at night. He's an African-American male. He's also purportedly wearing a hoodie. And the only actual ID that's made in the case is the police car driving one direction on one bridge, and Mr. Ellis allegedly driving the other way, as Megan just signaled. So they're passing each other at least 30 to 40 miles per hour at night. And so the officers try to pull this car over. A high-speed chase ensues. There's a crash. The person that's driving the car flees, and a gun is recovered in the driver's seat. And police search the car. They find the gun. They also find someone else's personal effects. And then they send the gun to the local forensic lab for DNA analysis. And so they recover some sort of DNA from the gun and a lighter in the car. And so now in this next slide, we'll see how the actual PCR analysis looked like from the state forensic lab. So we can see that there's two conclusions that are made, one for the gun, one for the lighter. We see that essentially they say that the data is uninterpretable, no comparison can be made using current methodologies. And so that's the actual result. I just snippeted that onto the slide. That's what I saw when I saw what the DNA results were in this case. And so I also so now at this point I'm like, great, this is a great trial case. They can't really prove ID. There's no DNA. But then I received something next. And I received this a document that had on it true allele DNA interpretation. And at this point I have no idea what true allele is. I've never heard of this. And I read it, and essentially it says true allele assumes that there's 3, 4, or 5 unknown contributors, and they give this kind of huge match number, 21.4 trillion is what they gave. And so now I'm looking at that, and I first asked my office, I'm like, does anyone know what this means? Nobody knew what it meant. And I just see this is really concerning. And I call the prosecutor, and he tells me, oh yeah, we have this great new technology. It's like, it's definitely Ellis's DNA on the gun. It's 21.4 trillion. I mean, the jury's just gonna eat this up. This is what the prosecutor's telling me on the phone. And I'm like, okay. So, please give me all the discovery, okay, is what I tell him. So, what does this really mean? So, this 21.4 trillion is an LR, or likelihood ratio. We just call it now for short an LR ratio. But so what it means is, what it doesn't mean that it's 21.4 trillion times more likely it's Mr. Ellis's DNA on the gun. What it doesn't mean is that Mr. Ellis's DNA is on the gun. And it also does not mean that the DNA is or is not on the gun. So that's the real kind of science or technology, what the experts will say at a trial about it. However, the prosecutor is going to try to say his DNA is on the gun, 21.4 trillion, right? That's what he's going to say. By the time the jury hears all the experts at the trial, they're just going to see a huge number, and then it's likely going to be a conviction just based off the number if the evidence is admissible. So that's just something to know. Another fun fact I have for you here is that a competing system analyzed Mr. Ellis's DNA on the gun and found a 1.44 thousand match. And so we see here that a competing system has 1.44 thousand. True allele is giving a 21.4 trillion match. And so we see here that the number matters, right? The higher the number, the more likely that, I guess, in a juror's perspective, that there's the likelihood, right, to that Mr. Ellis's DNA is going to be on the gun. And I
want to say, so about that, the second number that Kasia put out there, the other software that analyzed it, cybergenetics, but the prosecution side ran the sample with Mr. Ellis as the assumed contributor on, I think it was 4 other systems or something like that, as part of trying to evade disclosure of the source code. So they basically said, like, well, if we run it on all of our competitors' programs, which are open source, because I guess the other thing I should say about TrueAllele and StarMix is everything is considered proprietary. They don't disclose it. The assumptions the software makes are unknown. They're not shared. There's a lot of secrecy around them. And so what the government tried to do was say, well, if we run it through open source software, meaning you do know how the calculus is performed, and it says, quote, the same thing, note that it didn't say the same thing at all, right? That you have no reason to want our proprietary software. That was the government's argument for evading disclosure. So this was not like we didn't sit there and decide to run it through other software, but the government was trying to get away from disclosure.
Yeah.
Oh, yep. So a likelihood ratio as a formalistic matter compares 2 hypotheses to each other. One is that one of the so say you assume it's 4 contributors, one of the 4 is the suspect, and 3 unknown, unrelated individuals. That's the top, that's the numerator. The denominator in the likelihood ratio is that it's 4 unknown, unrelated contributors. So I think Kasia's precisely right that the government always points to it and they say, like, this is a matter of certainty because the number's really big, but it's actually never what it means. It's always a matter of probability. And as Dr. Matthews said at the start, there's no way to falsify it. There's no way to be sure that, like, that number is right or wrong, because every ratio is going to both assume it could be true and it couldn't be true, right? There's no way to test, like, the truth of what that number means. But the government always pitches it as a matter of certainty, the larger the number is.
Yeah, like when you learn to add, you may have had someone tell you that you should know how to do it by hand before you do it with a tool so that you can sanity check the answer you get. These cannot be sanity checked.
Right.
There is no correct answer, even if you were dealing with a sample that is totally constructed in a known way.
Right.
So that's really stunning.
Yeah, so at its basic, our issue is that we don't have confidence in TrueAllele's process or StarMix's process to come up with this number, because we don't know how it reaches its number, because we can't look inside the black box, right, to see how to double check, essentially. And so if we don't have process in the number, we can't have if we don't have confidence in the number, then we can't have confidence in the result. And so that's really important for our clients, because the result is always going to be against our clients.
Do we want to talk about
Yep.
how so now we're going to like switch gears and kind of tell you the story of how this case in particular unfolded and the various choices that were made along the way.
Yeah, so I looked at this true allele evidence, the conclusion, and I thought to myself, all right, how do I get rid of this? So two things came to mind: Dauber admissibility hearing and 702, and then Rule 16 in federal court are my discovery rules, the government's obligations to produce evidence. So first thing I did was self-educate myself. I basically consumed as much information I could about true allele, probabilistic genotyping, and everything we're talking about, because like maybe some of you right now, had no idea what any of this is. So I Googled, I Westlawed, I read law reviews, I read PCAST reports. I did so many informational interviews, and I also read the materials from cybergenetics. And so when I'm doing this process of doing informational interviews was very helpful, because I was able to meet lots of new people, very smart people, who knew about the topic, who could educate me, and then who helped me build a team to actually litigate this issue. So I made a list yesterday. I have about 14 people that I informationally interviewed, and this is like reading their stuff, calling them, having discussions about them, and just to name a few, I called Megan at Berkeley Clinic. I called people at the Innocent Project. I called Chris Flood, an attorney from New York. I talked with Professor Wexler, who is going to speak after us at some point. I spoke with someone named Nathan Adams, who is really the premier guy to do these sort of, to help you with any sort of probabilistic genotyping issue that you have. I spoke with public defenders from Nova Scotia, Canada. I spoke with, I read articles from Professor Roth at Berkeley Law. I spoke with Dr. Matthews, sitting to my left. I spoke with Dr. Heimdahl, a professor from University of Minnesota. I spoke to another public defender in Virginia. I spoke to John Ellis, who some of you may know, from San Diego. I spoke to Chris McKee from Colorado, who used to be the forensics head at the PDS in DC. I spoke to Jennifer Friedman, who some of you may know. She's now an AFPD in LA. And I consumed many other reports and spoke to the EFF and ACLU. So this was basically my process: informational interviews and learn as much as I can. And then from this, I started to develop issues of how to litigate this thing. So I read briefs filed by other attorneys in other cases. I saw how judges, prior to our case, no one had ever, I guess to give you some context, no one had ever been able to obtain the source code to one of these systems, especially in federal court, especially true allele. So there was not much case law, but I could look at state court opinions and see why, what the prosecutors were arguing, what the defense attorneys were arguing, and how the judges were striking them down. And I basically came up with how much time are we at?
A very detailed subpoena.
I came up with a very detailed subpoena to control the narrative, though. And so my narrative was going to be that software engineers and computer scientists are part of this Dauber analysis, which many people seem to have not made from the get-go. So the importance is here to do this early and control the narrative early, whereas the prosecution and these companies want to have the narrative to be probabilistic genotyping experts are the relevant experts in the field, and so we should only look to probabilistic genotyping experts for a Dauber analysis. The problem is there's only two of them. So, and they own their companies. So my thought is we need to get computer people in the room. They need to opine on this. And so everything I did through the next steps was through the lens of computer scientists and software engineers.
Yeah.
And
so I want to, one of the things Kasha did in the self-education, the drafting the subpoena that he was able to obtain, is he started really early. And so that's a thing I want to hit home for folks, is he knew what questions he was going to have closer to trial. He was going to want to litigate a Daubert motion. For some of you, that might be a Fry motion. But you also knew, I need to know more before then, and I probably need to be talking to the courts more frequently, so the judge knew what the concerns were going to be, right? And so that included starting super early in the case, as soon as he identified the issue, talking to everybody, drafting the subpoena, which, as you'll see on the screen now, there were some hurdles. There was some substantial litigation that was faced in opposition to the subpoena that was obtained, which included lots of different items. It's in the public record. We would be happy to share it with you, what it actually said. But one of the items was the source code for true allele. That is where most of the fight, I would say, eventually happened. We've put up, by the way, the Nixon Test, which, at least in federal court, this is the standard for when you can go to a third party with a subpoena to obtain information, and it's a 4-part test up on the screen.
Yes.
Do you want me to go to the dueling, the slide?
Yes. Yeah. So as Megan said, at the very basic level, I filed a very basic subpoena asking for a list of things, including the source code. Why did I ask for the source code? Is because all my experts in the case and everyone I talked to said, we need source code to double check how true allele produces its likelihood ratio. So I said, all right, then let's subpoena source code. So we did it, and we file the subpoena. We serve Cybergenetics, the company of true allele, and what do? They give the subpoena to the U.S. Attorney's Office, and now at this point, I'm litigating the U.S. Attorney's Office, who is now somehow representing Cybergenetics in federal court about issues of trade secrecy that Cybergenetics wants to make, issues of saying that it's not relevant to get the source code, saying that issues of that it's not relevant, that it's oppressive, that it's unreasonable. So basically going through the Nixon factors, and this process took about a year, I would say, a year of back and forth litigation, and I believe we submitted some of the motions that we filed, the briefs that we filed for you to read. It's also on the public docket, but this wasn't just we file one motion, they respond, we reply. I mean, it went back and forth.
4 or 5 rounds of briefing, and half a dozen, or no, more than half a dozen, almost a dozen declarations from various experts on each side about, seriously, dueling motions to quash the subpoena from the government and motion to compel compliance from Mr. Ellis's team. So when we say a year of litigation, there was a lot going on in that year.
I'd love to make a note here that they will try to say that there's been peer-reviewed studies of the method behind this, and that's all you need to know. But I want everyone to very clearly understand that in a peer-reviewed conference or journal setting, it is simply not the job of reviewers to assess the validity of software. They might be looking at the method in general, but that doesn't mean the method was implemented correctly or doesn't have bugs that trigger in certain cases. Besides, they're just not looking at it in that way at all. The only thing a peer reviewer says, are these results interesting enough to the scientific community that they should be published for them to read? That's a completely different question than, is this reliable enough for use in a decision that impacts life and liberty? Looks like we have a question.
Yeah, I was gonna say, so there's a question in the back. Right, so there's been no peer review on the software side, and I think that's in part, Dr. Matthews, correct me if I'm wrong, peer review in the software community is a little bit different than in the the hard science community. There have been some peer reviews of some elements of the science, but usually what we're talking about is peer review of in-lab testing and how a lab chose to, or how a lab validated whether they think they got the results they were expecting when they did in-lab tests. That's a totally different question from the software issues. And I also want to flag that the government and their experts will often conflate these two things, right? So the end user lab knew what was in a set of samples and they ran it in a particular way, and maybe that was peer reviewed or maybe it wasn't. So the lab thinks that their processes work and produce results that they were expecting is a separate question entirely from whether the software operates as designed and expected.
And from a software perspective, that's a lot more like saying I ran my homework on a bunch of things and it seemed to give me the right answers on those things. It is not the same as I deployed it in an environment in the real world and saw things I didn't expect when I was developing this, and I didn't get weird 21 trillion answers when I wasn't expecting it. It is not saying that. And as far as peer review of software, there is a well-established and understood process in software engineering, like the IEEE 1012 standard says what it means to peer review software. There's this whole definition of those doing the outside review have technical independence, managerial independence, and financial independence when we're talking about software at the most critical level. So one thing that this software standard does is it sets out integrity levels or criticality levels. If a piece of software is not impacting human life, maybe it's very low level, then you don't have to do independent verification and validation. But for something like this that really does impact very critical decisions of life and liberty, it should be, I believe, at the highest level, which includes independent verification and validation, and that would be the equivalent of peer review.
Right. So keeping an eye on time, so as part of the subpoena litigation, as I said, there were many, many declarations filed. We also consulted and quoted several law review articles, so there is scholarly literature out there written by people who went to law school, and so maybe a little bit more within the language that lawyers tend to use. We also, as Kasia mentioned, talked to the Electronic Frontier Foundation, the ACLU of Pennsylvania, although I know the ACLU National also has an interest in here, and I can't see if Nate's in the room, but I know Nate Fried-Wetzler will be here later. And on the issue of this kind of, should the source code be produced, there was some amicus support from the Electronic Frontier Foundation and the ACLU of Pennsylvania, who came in and helped explain to the court some of the issues that Kasia just wasn't, the procedural status was a little weird for Kasia to be opining on. This is really important because it's going to matter for Daubert, because there's a confrontation clause issue here, right? And so amicus support was able to come in and help the judge really see the stakes and the contours of the legal issue, why it mattered now to get access to the source code, and how it would affect Mr. Ellis's rights, and also the subsequent litigation. So I want to put in a plug, as somebody who works at a law clinic, that amicus support in criminal cases I know is not something that everybody is used to or has thought about or done, particularly not at the trial level, but there are plenty of times when you're litigating complex tech issues where it actually can be very helpful, because maybe you want to have some folks come in who have computer science backgrounds who aren't your hired experts, and there are people who will opine in those situations. Dr. Matthews did this in New Jersey versus Pickett.
I did.
Or civil liberties and civil rights organizations, tech law organizations that will come in and help the judge see a different side of the issue than you are positioned to take or to pursue because you're representing your client's interests. So again, keeping an eye on time, Kasia already previewed this, but at the end of this, after a year of litigation, what happened?
So I wanted to just go back one step, Megan, because I wanted to point out that as part of this litigation, and I know we're short on time, and there's so much to say, but the four kind of main arguments you're going to see is that these companies are going to say, trade secrets, trade secrets, trade secrets, you can't look at our source code, it's going to get disseminated, we're going to lose millions of dollars, and that's going to be the end of us financially. And so that's one of their main arguments. and Professor Wexler has written extensively about this and is probably the expert in the country, if not is the expert on the country on this topic. So we borrowed a lot from her to have the judge understand why in a criminal case, this argument about trade secret protections is really not relevant, because there's legal issues, and plus in civil cases, there's protective orders all the time for huge companies giving each other source code, like Apple and Google sharing source code with each other. Another major argument is, look, everyone else lets this in. You should let it in as well. And look at our peer review articles that Dr. Matthews mentioned. So in our last slide where we had be nitpicky is, all right, we looked at those peer review articles. I didn't really read them, too difficult for me. I gave them to my experts and had them read them, and what did they figure out? Source code isn't mentioned in any peer review article, and guess what? Dr. Perlin, who is the owner of cybergenetics, the creator of Allele, is somehow associated with every single peer review article that's out there about his own system. So there's obviously an inherent bias here that he's part of the board, essentially, or the peer review of his own machine. And then the last kind of major part of the litigation was you don't need source code to test reliability. And that's where really the meat of our litigation was, where we brought in the EFF, the ACLU. We had 12 or something declarations explaining why you actually do need source code to test reliability. And then in the end, we won. So we got the source code, and it was the first federal decision ever to disclose source code from a probabilistic genotyping system of true allele. And so the judge, you can see the order here. The judge says, fundamental fairness requires access, and we were really happy when we got it. And then the next kind of step within that disclosure order was a protective order, which is our next slide.
So the judge, as the order indicated, said, now you all go negotiate a protective order, which was, there were subsequent fights and disagreements over what the scope of the protective order should be, what should be included within it. And I would say that this is something that I want to flag for everybody. If you do get a disclosure order, the protective order litigation, I think one of our takeaways was we knew it was going to be important. I think we may have underestimated how important the language in the protective order was going to be. And this was in part because what happened in our case, what happened in the Pickett case in New Jersey that I mentioned before it was otherwise resolved, judges are relying on model protective orders from patent cases when they are trying to decide what a protective order should look like in a criminal case. I want to let you know, as somebody who works with patent litigators and IP experts, the interests in a patent case are fundamentally different, not shockingly, than they are in a criminal case, but so is the nature of the disclosure that's being made. So the model protective orders that are being relied on are actually just wholly out of step with the needs of criminal cases themselves.
Yeah, if you have two pieces of software and the question you're trying to ask is, did this piece of software steal a piece from this one? That's a completely different kind of review than, is there evidence to say that this piece of software is reliable in this case? Completely different question. And the way, I think we put a lot of thought into the protective order and got pretty broad language, like all software dependencies, including all the software engineering documents recommended by the IEEE. But even with that language, we didn't know the ways they would weasel out of that. For example, they didn't give us access to back-end databases, where databases are clearly a dependency. You would think that would be there. So from now on, I would totally put the word databases in there and fight tooth and nail for it. But you'd think all software dependencies would do the trick.
We also ran into an issue around language about build instructions. So if you're talking to software experts, what they will say is you need the source code. You also need what's called the executable code, which is like the program that was actually run to do the analysis. And then as it turns out, to get from A to B, you need the instructions for how the code is compiled, how the system is built. And because the protective order, which actually included a little more disclosure order language, that was the other thing that made this very complicated. We had 2 disclosure orders. It didn't specifically specify you need the build instructions to get from point A to point B. And so cybergenetics and the government withheld that. And this led to, we were alleging and pointing, not even alleging, we were like pointing to specific instances where information we thought the protective order and the disclosure order covered, some of which Dr. Matthews just pointed out, wasn't disclosed, right? And so we had to go through not just a round of litigation about the terms of the protective order, but also the disclosure the government did or didn't make in response to the order. So we had subsequent litigation, and I want to jump forward to here. As part of this, and this is, I just want to flag this, Kasha, and you can weigh in here too, because of the odd procedural posture of this particular case, there was a motion for reconsideration that was a little jarring in the middle, where the government, as part of litigating the protective order language, said, we think you need to reconsider your order to disclose the source code. And in the judge's order on the motion for reconsideration, Kasha, what was the exact language that came back to bite us later?
So the government filed this motion to reconsider. We responded, no, that you got, you're right, judge. And then the judge, in her order, kind of in dicta, wrote, some access is necessary, kind of just like one sentence saying some access. And so that came in and bit us in the butt in the end, because we ended up, once we continued with our litigation for the violations of the protective order, the judge essentially said, she's now retired, said, I don't really understand any of this stuff. I'm going to get a special master involved. And so the special master, as I think Megan tells the story better than me.
Can I tell you what they tried to, I'd like to tell everyone what they tried to give us, okay? Catch this. They tried to give us 2 computers. One where there was the executable, which is a closed box system, can't look inside. And the other, which is a pile of source code files. They were actually pulled out of their normal directory structure and put all together in a big pile without instructions of how to put them together. And the engineering analogy to this would be like, say you had an airplane, and you wanted, or a car, and you wanted to be able to see if it's reliable. And they gave you the car, the airplane, but you can't look inside of it. You can't pop the hood, you can't do anything. You can just do testing on it as a whole. And then they gave you a big bag of parts, all the pulleys, all the nuts, all the things, all mixed together. So like the parts of the transmission is mixed with the brakes, and then they don't give you the schematics of how to put them together, and they say, that's enough, right? When what we wanted, and what is appropriate, is we want a fully working version where we can watch Mr. Ellis's data go through the system and see if it's taking any weird or error paths. That is only right. There's no amount of acceptance testing that can rule out that it took some weird error path in any particular case. And if, like in this case, it is such a crucial piece of evidence that makes all the difference between him being there or not being there, it is reasonable to say, I want to watch his data go through the system and see if it takes any weird paths. And we were unable to do that. And they said, you can test each individual function, right? I'm like, that's like testing each screw. Like, is it a screw? Does it have the right strength? That is not the same thing as testing the car or the airplane. And we made these arguments very clearly to the special master, and they took a very narrow view of the decision that they were making, unfortunately.
Yeah, so as Kasha said, after the motion for reconsideration, as kind of things were heating up and the stakes were rising, the judge on the case was in the process of retiring. And she was like, it's too much, I don't understand, right? So this is one thing I want to flag, is that your judges are likely to not understand, and it's going to be more overwhelming for them than it is for you, and I would venture to bet that it's going to be pretty overwhelming for you when you start litigating these issues. And so what she did, again, this is an odd procedural posture thing, was she sent us all to a special master, which is effectively a court-appointed expert who is a lawyer who is tasked with writing a report and recommendation to the judge about how the judge should settle the issue. So in this case, it was an intellectual property litigator who had litigated issues of source code in patent cases. As I said, totally different context, but she at least had like some understanding of software, some understanding of trade secrets, some understanding of how you do some amount of testing of source code. And she was hired by the court to effectively hold hearings, read the briefing, and make a recommendation on what the judge should do in the litigation about whether the government had complied with the judge's previous disclosure orders. This is important because in this case, it was the first opportunity for a hearing. It was the first time a decision maker was listening to actual experts and not just lawyers channeling experts and helping contextualize declarations and things like that. The importance there is that Kasia had been asking for a year and a half at that point to have a hearing on any of the things that we were litigating, because what we knew was the judge didn't understand what was going on, and we were doing our best to explain it to her, but she needed to be in a situation where she could ask the experts questions, because we were just trying to anticipate what she might understand or not understand, and we knew neither the government nor we were right about, but we were right on some things, but we also were missing things. But the judge was just very hesitant. And so the special master was the first time we had that opportunity. We can talk a little bit about the things we won and the things we lost at the special master stage. The judge ultimately upheld the recommendation of the special master. But I do want to say that I think actually the process was quite helpful. I think it would have been more helpful had it been in front of the actual decision maker, the judge, because then, we wouldn't have had this whole conversation with a person who's only involved in the case for, 10 minutes and then isn't there anymore. But I want to put in a plug for trying to get in front of your decision makers earlier with your experts so you can be having these conversations. And as Kasia mentioned earlier, this is really part of the narrative of teeing up the issues. So by the time you get to motions to exclude the evidence, the judge better understands the stakes, the legal issues, the software concerns, and all of those things.
Just to give you an idea about what the special master hearing looked like, the government complained in their briefings that we used the same kind of team nationwide. We actually did have some additional people, but Nathan Adams, who's commonly used in these probabilistic genotyping cases, is usually hired by defense attorneys nationwide for these types of cases. So I saw them make that complaint to the judge, so I said, all right, I'll get another PhD in computer science from Johns Hopkins. So we hired another computer scientist. So we had at our special master hearing a PhD from Johns Hopkins, Dr. Matthews. We had Nathan teed up. So we had 3 experts in computer science to litigate computer science issues at issue in the protective order. And the protective order, one of the main issues was, what is reasonable source code review and testing?
And we got a lot of amazing statements in that special master that really should have carried the day. So we'll live to fight another day. But, another thing that's really worth noting is how many things don't even exist, right? The design documents
there were things we asked for that we got them to say on the record, basic parts of building software systems that they conceded do not exist. They didn't do documentation that never happened, that any even like intro to computer science student would be like, you absolutely need to have A, B, and C when you're building a software system. And they were like, we don't have those things. They've never existed. We can't build them for you.
So the government hired another expert themselves, another computer scientist, to kind of be a two-part with Dr. Perlin, who is obviously biased, and he's going to say whatever he wants. So they brought someone in that's not part of the company. That expert basically testified for us, because while he did say some things on direct, on cross-examination, he said everything correctly about what, in line with what our experts were saying. So after the hearing, I walked out of that hearing saying like, all right, we won this. I mean, we won on the technical expertise side of it, but we lost because the special master, in interpreting 3 different orders at this point, first being the initial disclosure order, source code is fundamental, you can review it and test it, to the some access denial of the government, you only get some access, that kind of dicta language, and then the actual protective order, which says like all dependencies, all reasonable testing, reasonable searching, reasonable reviewing. And so in kind of denying us, the special master recommended that the judge didn't want to give us complete access, even though I guess that's what all the experts were saying in the room, because she said some access in her denial of the government's motion to reconsider. So kind of like that's where we failed. And so if you're coming up, if you have this issue, please come talk to us or other people that I listed, or people that are at this conference, other speakers, because this was really where we failed, because we got that some access language, and then we couldn't. It was the judge's order versus what does science and technology actually say about the issue.
Right. We only have a couple minutes left, so I think we're going to breeze through the reflections, but as I'm advancing the slides, I also want to point out that the hearing was one of the first times that Mr. Ellis was able to see Kasia advocating for him in court. And so the other benefit to pushing for hearings and having people show up is, even though these issues are complicated, even though like I do this stuff all the time and I sometimes get lost, having a client in the room able to seeing you fight is important, as you all know. So that was just our first opportunity for that to happen.
And just one thing to add, this was a 3-day hearing with me spending, sitting with your expert is important. I think everyone's heard this. I sat with and I thank Lisa Freeland, my federal defender. She provided us a lot of funding for the case. I basically learned how to test source code, at least cross-examine on it and be confident with the questioning I was doing. Maybe 2 weeks prior, I would spend 4 to 5 hours a day with my expert. So that's how much it took me. Maybe it'll take you less, but just to give you an idea of what was the preparation that led to this 3-day hearing.
If it's okay with you all, I think I'm happy to just breeze through the reflections, yeah?
Yep.
Okay, so the very first thing, and we said this earlier, is try to issue spot and litigate early, right? So you litigate a subpoena or discovery motions early so that you have enough information to get to your Daubert and Frye hearings right before trial. So you already have information in the record, and you have the ability to plant those seeds of doubt in the judge's mind for when they're ultimately deciding whether this evidence comes in or not, right? So do this as early as you can, and the reason I want to flag this is, and no knock on anybody, right? But I get a lot of calls at like Daubert with lawyers who've said, I haven't actually been litigating it that much beforehand. I have though the results, right? I have the analysis, the DNA analysis, is that enough? And the answer is like, well, you can do a bunch with that, but having a clearer record can make those subsequent litigation questions easier. The second thing, and this I think is Kasia's big takeaway, is it takes a bunch of people. Right? It takes people actually on your team. So I think consulting counsel on the case, there are experts retained in the case, but it also takes like talking to all of those people Kasia mentioned, talking to us in your cases, right? we as a defense community are learning these things together as we go, and people are incredibly generous with their time in helping you see what was successful, what wasn't. Are there samples out there, are there not? Is somebody willing to help you work on cross prep or things like that? This is related, talk with the people who have done this before. Again, some of us have like samples, right, that we can point to. We may also know of just other cases. For example, I don't remember how we found out about the Nova Scotia case, but there was a case in Canada where they had litigated this that directly contradicted things that true cybergenetics was saying in federal court filings. They were making allegations that were simply not true. And I think we talked to somebody who said, oh yeah, there's this like Canadian case, you should go find it, right? Which we did. So talk to people who have done this. The rumor network is great at giving you pointers. Nitpicking is really important when it comes to DNA software, but I would also say more generally about tech stuff writ large. And I think that the speakers throughout this conference are going to help you see the importance of nitpicking when it comes to what the government says a piece of technology does or what is possible compared to what it actually does and what is actually possible. The prosecutors in your cases are rarely going to know that much more than you do about how things function, and there's real merit in digging deep and going after everything they say about what studies say or what can happen or what the settings let you do, because they're going to get it wrong a lot. And you're going to look more credible and be in a better position for having like done the legwork, as hard as it is. And believe me, I know it's hard. The second to last one I have, this is a John Oliver joke, if anybody follows John Oliver. Amici can be really helpful. As I said earlier, the Electronic Frontier Foundation, the ACLU, their speech privacy and tech team. You can also talk to computer scientists. You can talk to law clinics. There are lots of people who are in this kind of tech meeting the criminal legal system space who may be able to give voice to concerns that you aren't well positioned to do or where the procedural posture makes it awkward. So talk to folks. Maybe they'll file an amicus brief at an unexpected juncture that can really be helpful in advocating for your clients. And the last one that I want to flag, and Dr. Matthews kicked us off by talking about this, there are real debates in the computer science community about what black box software does, how it's used in the criminal legal system, probabilistic genotyping software being one example, but the same is true of predictive policing algorithms or risk assessment tools, right? The computer science community is having these conversations too, and so it's worth looking beyond the bounds of just the legal cases and the court opinions that exist, because these are the folks who actually know how the software works or who might have a sense of how it should work or should have been built. And so know that these debates are happening and try to get folks involved who have a better sense of those technical issues than you do. And I'm only 2 minutes over. Here's our contact information. Thank you for being here so early on a Monday morning to talk with us about this.